Earlier, we told you about what's been happening in Rivers State as regards to impeachment of Governor Siminalayi Fubara. Right now, Eze Onyekpere, a lawyer and public policy expert, joins us from Abuja for more on this story. Thank you so much, Mr. Onyekpere, for joining us. Now, I want to know if the High Court restrained the Chief Judge from receiving impeachment notices, can an acknowledgement of receipt still be legally valid?
Well, under our law, in the determination of civil rights and obligations of citizens or any parties to a dispute, the court has jurisdiction to make a decision. So once there is a court decision, either deciding one way or the other in the course of a disagreement, parties are bound to obey the decision of the court, pending when they go back, if it's an interim order, to set it aside or to appeal against the order. So once there's a court order, that court order takes precedence over the course of the proceedings.
So tell me, does simply acknowledging documents amount to acting on an impeachment process, especially in the violation of the court order?
Well, to be honest, I've not read the court order to know exactly what it forbade or what it mandated. So whatever is the mandate of that court order, yes, you can serve a process, but if they say stop action and you have not served the process at this time it says stop, you can no longer serve. Even if you have served, the days don't start counting for the person who has some days to respond until you vacate that order. So it depends on the exact wordings of either the mandates or the prohibition, either a prohibition or a mandatory order given by the court.
So which takes precedence here, right? The House's impeachment powers under Section 188 or a subsisting High Court injunction?
A subsisting High Court injunction takes precedence until it is vacated, because the dry letters of the law in a statute or a constitution, they don't apply on their own. It is for the courts to interpret them and give life and meaning to them, because law has been severally defined, and one of those definitions is that law is what the judges declare as the law. So yes, the House of Assembly may have started this process, but it will be subject to a judicial interpretation to determine the exact latitude and the exact things they have done or ought not to have done in the process of the impeachment. So,
looking at how things have turned out, is it possible for the Chief Judge or the lawmakers, to be exposed to contempt of court if, for example, the process continues in any form?
If the process continues in flagrant disobedience of a court order, contempt proceedings could issue. But like I said, it depends on the exact wordings. If it's to say, stop the impeachment proceedings until we hear the motion on notice, maybe it's an interim order, because I'm sure whatever may have been gotten must be an interim order. The other parties have not been put on notice for them to argue the case, counsel from both sides. You have to stop until the court vacates the order or until the court orders otherwise.
Now, at this point, is the impeachment process legally paused, suspended, or is it completely voided, until the court rules?
Well, like I did say, if they say stop, is a pause, okay? Because you, as a party on the other side, will also have the opportunity to go to the court to say, no, my lord, the order is not proper. These are the reasons why we should continue. If the court in its wisdom thinks that you've made the right point or what you are doing is in accordance with the law, it will vacate the earlier order it has made, because it's likely what may have been made may be an ex parte order. That is upon hearing the deposition and application of only one party. So by the time the two sides are in court and they present their case before His Lordship, then either the order is vacated or affirmed, or a more proper order will be substituted. So these are facts. It's just the usual judicial process.
Now, what legal options are now open to Governor Fubara and his deputy to enforce the court order?
Well, if the court court has given an order, there is a procedure for the enforcement of the order. The thing is that it's served on the adverse party, maybe the House of Assembly, the Speaker, and once it's served on them, they have a constitutional duty to obey the decision of the court. And then if they don't like the order, that's why I'm saying they have the opportunity to come back and it's be hard to seek a vacation of the order.
So if the Assembly insists it has complied with the Constitution, I want to know who ultimately determines that. Is it the Parliament itself or is it the courts? So I'm hoping you can still hear me. I was asking if the Assembly insists it has complied with the Constitution.
It is not for the Assembly to determine the law. I mean, they are a party to the suit. They need a court to pronounce the propriety of what they have done, whether they have conformed to the law or not, because the opposite party is saying you have not done the right thing. That's why they went to court to say, set it aside. So it is for the court. The court has the final say as to the propriety of the action of either the executive or the legislature.
Thank you so much, Mr. Eze Onyekpere, for having this conversation with us.